Hello everyone, this is Snigdha Mohapatra, intern at LEXCLIQ, and in today's video, I will be talking about meetings under company law. A company can be defined as a legal establishment encompassing a group of individuals engaged in operating a business. Management of a company requires efforts undertaken by a lot of individuals who discuss and deliberate upon issues before a decision is taken. The decisions are often taken in meetings, which is a formal dialogue between administration of the company, generally the directors, and in some cases members too, who discuss the affairs and business of the company. Now there are certain kinds of meetings that take place in a company, which I will be discussing in this video. The first is annual general meeting. Now, an annual general meeting refers to the meeting which is held annually by the companies. It is important for every type of company, whether it is a private or a public company, limited by shares or limited by guarantee, to conduct an annual general meeting once in a year. There shouldn't be a gap of more than 15 months between two annual general meetings. An exception is given when a company is incorporated. In such a case, the company may not conduct an annual general meeting in the year at all. After incorporation, the company needs to conduct an annual general meeting within 18 months. According to Section 166 of the Companies Act, the first meeting after incorporation of the company must be held within 18 months. Subject to the exception of incorporation, there shouldn't be a gap of more than 15 months between two annual general meetings. Except for in the case of the first annual general meeting, the registrar has the power to extend the annual general meeting for a time period which should not be more than 3 months. A notice must be given for annual general meeting specifying details such as date, place of the meeting, etc. The notice served must specify that the meeting is an annual general meeting, and the time and date assigned for it must be during business hours and on a date which isn't a public holiday. The place of the meeting should be the registered office of the company, and if not so, then it must be within the town, city, or village in which the company is officially registered. According to Section 167 of the Act, in case there is a default by the company in conducting the annual general meeting, and any member of the company files an application of the contravention of the said default, the regional director of the company law board may call for a meeting or direct holding of a meeting where the provisions of Section 166 and 167 of the Act are contradicted, then in such a case, a fine can be imposed on the company and every officer of the company responsible. A notice is to be served in advance of 21 days for the annual general meeting, but in case the notice is not served before 21 days and all the members who are entitled to vote in the meeting agree for an annual general meeting, then the meeting can be called with shorter notice. The matters which are taken up to be discussed in an annual general meeting are known as ordinary business. These are the matters which are discussed in every meeting. Ordinary business constitutes discussion of annual reports, important reports such as director's report and the auditor's report, declaration of dividend, the appointment of directors, etc. Apart from ordinary business, a special business can also be discussed in an annual general meeting. The second type of meeting is extraordinary general meeting. The matters which constitutes to be the ordinary business of the company is discussed in a statutory meeting, an annual general meeting. To discuss the matters apart from ordinary business, that is special business, are held in extraordinary general meeting. Any meeting which is called apart from statutory meeting and annual general meeting is called a extraordinary meeting. Extraordinary general meeting is usually called for discussing matters which are urgent and can't wait to be discussed in the annual meeting. The extraordinary general meeting can be called by the directors of the company as well as by the shareholders who hold at least one-tenth of the paid up share capital of the company. Shareholders can make a requisition to the board of the directors of the company to call such a meeting. If the meeting is not arranged for even after requisition by shareholders, then the shareholders may convene the meeting. According to Section 186 of the Companies Act, Company Law Board has the power to call an extraordinary general meeting, but not an annual general meeting. Shareholders of the company are empowered to convene a meeting within 3 months if it is not convened within 21 days of requisition by the Company Law Board. In an extraordinary general meeting, matters like alteration of clauses of the Memorandum of Association, changes in the Article of Association, schemes in relation to share capital are usually discussed. Any matter which needs to be discussed upon an urgent also calls for extraordinary general meetings. In case the extraordinary general meeting can't be held due to some reasons, then the company law board can call the meeting on its own initiative. Now, the third type of meeting is board meetings. A secretary or a director of a company has the power to call board meetings. The board meetings can be called by the secretary or a director by following the procedure which is laid down by the Companies Act 2013. The meeting can be called on the direction of the chairman or the managing director. Any director can requisite to convene a board meeting, and then on such requisition, the manager, secretary, or any director can summon a board meeting. Notice for such a meeting is to be served in advance, and it should be done under the company's authority. If a notice for a board meeting is sent without any authority, then it will be considered to be an improper notice. In case a director wants to convene a board meeting to discuss some urgent affairs, then he must do so with the permission of the managing director of the company. In the case of Sanjeev Kothari versus Vasant Kumar Chodia, it was observed that if a meeting is convened by the managing director on requisition by the director on the same date at the registered office to discuss the same matters which was brought forward by the director, then the director must attend that meeting and should not arrange any other meeting on the same date at some different place. Thank you so much for watching the video, and please subscribe to the channel.